A Florida judge decided to temporarily block the state's recently passed abortion bill from becoming law. House Bill 5 will ban nearly all procedures after 15 weeks of pregnancy here in Florida. Bills opposed by reproductive rights organizations, including Planned Parenthood, the American Civil Liberties Union, who sued the state to block the bill. Joining me on the morning show, News4JAX political analyst and the head of the Jacksonville University Public Policy Institute, Rick Mullaney. Good morning, Rick.
Good morning, Bruce.
So, Rick, Judge Cooper issued a verbal ruling, and until he puts it in writing, it's officially not official.
That's correct, Bruce. Under the statute, today, as we're speaking, it's 15 weeks in Florida. To put it in perspective, yesterday, 24 weeks. Today, under the statute, it's 15 weeks. However, when the judge enters his order, which will enjoin the statute, it will go back to 24 weeks. However, when Governor DeSantis takes the appeal, that order could be lifted, in which case it would go back to 15 weeks. A little bit confusing, but in the end, this is heading to the Florida Supreme Court, and that's where it will be decided.
Okay, so Judge Cooper is expected to put it in writing sometime next week, and that's it. Cooper ruled that the law is unconstitutional because it violates the privacy provision of the state's constitution and, quote, does not meet the standard of the Florida Supreme Court rulings that protect abortion rights in the state. So in other words, has the Florida Supreme Court decided that women have a right to privacy under the state constitution to not have that right compromised up until at least 24 weeks?
Bruce, that certainly is the ruling of Judge Cooper, and there's good reason for that because the right to privacy is explicit in Florida's Constitution, adopted in 1980, and there have been Florida Supreme Court opinions confirming that right to an abortion. However, when this is litigated before the Supreme Court, there are three possibilities. One, the Florida Supreme Court could find that the right to privacy in the Florida Constitution extends to 24 weeks, and if it does, this statute will be unconstitutional. Second, they could find that the right to privacy includes the right to an abortion, but extend it to 15 weeks. And by the way, that would be consistent with what Justice Roberts was advocating in his concurring opinion in Dobbs. But Bruce, there's also a third possibility. They could revisit this entirely, and they could go back and find that the right to privacy in the Florida Constitution was misconstrued. This is what Governor DeSantis is arguing, and that in fact that right to privacy does not contain within it a right to an abortion. And the argument would be, at the time of adoption in 1980, it had nothing to do with abortion, it had to do with personal information. Roe versus Wade was adopted in 1973, there was no need for it. So in the end, Florida Supreme Court, three possibilities. We're going to have to wait and see.
So with the ruling that was tendered yesterday, it started with proceedings in the courtroom before Judge Cooper on Monday. Closing arguments were tendered yesterday. Is he basically saying overall the state's argument to enforce the law was not, quote, legally efficient? I think this is what he wrote in his preliminary judgment here, to justify the statutory ban, calling the providers' witnesses more credible than what the state presented.
Bruce, that testimony was important, but in the end, it's important to remember what the role of Judge Cooper is. He is a trial court judge. He is bound by the rulings and the precedent of the Florida Supreme Court. And in his questions to lawyers, he asked them about that effect of those rulings. For Judge Cooper, although that was important, what was more important was his view of the rulings of the Florida Supreme Court. He's bound by their precedent, and therefore I think he believed he's compelled to find it unconstitutional. However, when it goes to the Florida Supreme Court, they are not bound that way. They can modify that precedent, they can overturn that precedent, or they could confirm that precedent. That remains to be seen.
Okay, let's take a look at the big picture here. Beyond abortion, there's the privacy issue, and that's what's taking center stage here. You and I talked about this when the Supreme Court handed down the ruling on Roe v. Wade. Judge Clarence Thomas, when he issued his opinion on Roe v. Wade, basically said some of these same rulings can apply to the issue of contraception and same-sex marriage. If you take into consideration Judge Cooper's thinking, again, looking at the broader picture, can that same theory apply?
Bruce, I don't think so here, but for Justice Thomas, what he was really concerned about was that he wasn't really anti-contraception or anti-same-sex marriage. He's anti-substantive due process under the 14th Amendment, finding non-enumerated rights, and that Roe versus Wade found an implicit right to privacy, for example, that's not in the Constitution. The Florida Constitution, however, it's not implicit, it's explicit. It is in the Florida Constitution. Therefore, what the Florida Supreme Court is going to do is not look to an implicit right to privacy, but one that is contained within the Constitution. And the argument is there is a Florida constitutional right to an abortion. However, similar to Justice Thomas and the conservative judges, there will be a conservative versus liberal construction of what does the right to privacy mean under the Florida Constitution. And for that, we're going to have to wait and see what the Florida Supreme Court says.
Then there was another lawsuit that was filed by members of a synagogue in South Florida on June 10th. They said, look, this violates our right to religious freedom. So there are some other issues that are at play here as well.
There are, and you will see some novel arguments. In that case, what they were arguing there is that under the Jewish faith, life doesn't begin until birth, and that the life of the mother has primacy. Not so sure how at odds that is with the Florida statute. In the end, in states across the country and in Florida, you're going to see some new arguments presented. But in Florida, it's going to be very state specific. And in Florida, it is state specific. It's the interpretation of the Florida Constitution.
This is a very complex issue, and it's not one that's going to go away soon.
It is not, Bruce.
Nor is the debate. Well into the midterms, 2024 and beyond. Rick, always a pleasure. Thank you.